national layers, right? So obviously South Africa is the national layer, and then there's a regional layer and a UN layer. I refer to both of them as international, right? Because what is not national is international. International can be at the regional level, and that obviously is under the auspices here of the African Union. And what is global is under the auspices of the United Nations, right? So if we think then of today's topic, it really concerns the fundamental question: why should we be concerned about looking at protection for our rights, the work that we do from a human rights perspective, beyond South African law, beyond South African framework? Is there anyone who wants to give your sense? You know, why is it that there is a whole UN system of protection, and now we talk about an African system of human rights protection? Why is it that we cannot just say South Africa has a very, very good system? Let's focus on it. We'll find all our solutions in South African law. Can we say that? Yes, please.
I think it's because at some point, it became quite clear that states had to be able to be held accountable by other states and their peers with regards to their treatment of their citizens and neighboring, the other states. And as such, South Africa is signatory to various instruments, not just at UN level, but also at AU level, which then make it accountable to that body, and therefore a lot of the legislation in the country has to be aligned to those instruments that it has signed and ratified in the country.
Okay, excellent. I hear you say we are part of a global community, right? And we want to see that at least in this global community, all the states uphold a certain minimum standard. And to make that happen, there has to be accountability. There has to be a formalized relationship between states. We have rogue states, if you like, right? Let's say North Korea. And that is problematic because they really are not part of it. But for all the other states, even if they commit human rights violations, they try to be, to a certain extent, part of this kind of common standard system. Good. Any other reason why you think, we should not be content or perhaps satisfied to just say all our solutions lie in South Africa and South African law from a human rights point of view? Yes, please.
I think we also need to benchmark ourselves with the best in the world, and then sort of dovetail what they are practicing towards our own legislation and so on.
Because yes, continue.
We're still a young democracy, and
Okay.
we develop from learning from other democracies and states.
For sure. If you look at the South African Constitution, certainly it's been influenced, right? Even the Constitution we know has been influenced by other domestic systems, but also by the United Nations, by regional systems. And it's continuous. It's not only true of South Africa, it's true of all states. So we are saying that international law is like a gravitational force, I like to say, right? It's like it pulls all the states together to at least, have a common understanding and to be influencing one another with best practices. So that's another reason. Another point, yes, please, that you think why we need to look internationally.
Well, basically, just like at national level, we have different levels within the court systems. At international level, we also have to look at it from a perspective where if we exhaust our remedies nationally and we're not satisfied, we should be able to look to another entity that will adjudicate on that particular issue that we are concerned with.
Exactly. So it's in a sense that the international system is a safety net, right? Because we have a good national system, but sometimes and somehow someone will fall through the cracks of the national system. It's inevitable, right? It's just how it is. And then the international system is that safety net underneath that catches the person whose rights are violated. We hope, right? That's potentially so. So it's not to say we want to be overly critical of the South African legal system and legal protection, but we want to assess it against a different standard. We want to see the influence of that standard, and we want to make sure that if our system doesn't, provide the remedies, that there's some form of higher and further recourse and redress. And actually, I have one example here. Is this how I go? Just assist me here to go to the next slide. There we go. When we talk this afternoon or later with Victor about the African court, I just want to give you this one example. Look at this case. It's a case of someone in Tanzania that ended up before the African court, right? It's called Malia. Now you can see, I give you lots of dates there, but the story is that Malia is someone who was convicted of having been found guilty of raping a 7-year-old girl, so it sounds like a very serious offense, right? And convicted, sentenced to life imprisonment in 2000, in the year 2000. He was only 15 when he was alleged to have committed this crime. So, from the outset, he insisted on his innocence, right? He said that, he was innocent and the fair trial rights were not guaranteed. But through the process, his efforts to get his case heard by an appeal court were thwarted, were not successful because the court record was not prepared and delivered to his attorneys, and an appeal could not be lodged. So he spent his life essentially from that time until 2016 or 2015. He got wind of the fact that there is an African court, and he got lawyers who submitted his case to the African court. And once the African court started to look at this case, they saw that this was a serious miscarriage of justice. So even, we could say, the court then called for the records to be given to it, and they quashed the conviction. So in May 2016, the African court, having looked at this case, declared, that his rights were violated, and after serving 15 years and 9 months, he was released. So, it's a very tangible result, right? So it's that idea of the domestic remedies not working, right? You have to exhaust your local remedies first, right? So that is the relationship between the national and the international. If you want to find a remedy at that international level, you have to make sure that you find a remedy first at the national level, right? The so-called exhaustion of local remedies. Because the primary obligation to guarantee your rights is on the South African. But there is a subsidiary or a complementary system that comes into play. And Mr. Malia's case illustrates just in a poignant way how, that system can make a very real difference to people's lives. And we have examples in South Africa that we can also use. So, when we talk about the African system now that we'll focus on, this, in other words, the AU system, if I can call it like that. So there's the UN system at the outer level, the AU system, and the South African system. Now, we want to just make the point that this system of human rights protection functions not like in a vacuum. Who put it together? It's the African Union. It is an intergovernmental organization, right? You see the word, intergovernmental organization. In this case, the African Union. It used to be, obviously, previously, initially of our independence, after our independence, the organization was called the OAU, right? The Organization of African Unity, but it's the same. They're basically just a continuation, legally speaking, of each other. So that is important to, I think, realize. Because it doesn't mean that it's been set up just for human rights purposes. Why has the AU been set up? For political purposes, for solidarity, but inside that broad agenda of the African Union, there is human rights. And that is the angle that we try to make use of. But our potential of using the AU system, because it is essentially a politically established system, it has constraints, doesn't it? Are the African states all very democratically minded in terms of governance? We've seen a number of illiberal democracies arising. We've seen coup d'etats, right? Just the other day, we saw it again in Mali, Chad, Burkina Faso. So the point about my intervention here is to remind us that we cannot over-expect. Okay, we want to expect something from this African Union system, but it is a system made up by the states themselves. And how many states are there in Africa, by the way? It's debatable, right? And that's a funny answer. If from the UN perspective, it's 54. But there's one state which the African Union recognizes, which the UN doesn't recognize as a state, which is the Sahrawi, yeah? The so-called Western Sahara, the state that Morocco has a contested border with, or sovereignty issues. So let's say 55. For our purposes, 55 African Union member states. So we have to just be constrained in our expectations. So in 1963, this intergovernmental organization that created what we now know as the African system was the OAU. It was founded, the OAU, as you know, in 1963, right? By the states that just recently gained their independence. In the year 2000, 2001, the OAU transformed itself into the African Union. So it got a new constitution, but essentially, you know, there's much continuity between the two. Okay, so let me just go back very briefly to the the OAU of 1963. Okay, yeah, maybe we skip that one. So the 1963 OAU Charter, and now I am a teacher after all. I'm going to give you, you know, just like one other purpose of the gathering is for you to see this book is your manual, right? If you want to do anything with the system, obviously we're not going to cover the whole thing today, but at least you'll have it, right? So we're gonna try also to make you a little familiar so that when you need to answer some questions, you can find your way through this, right? Obviously these documents are also available on the internet, but they're put together for us here. So if you look at this compendium, as it is called, on page 2, just to kind of give you a sense of the things that are here, you see there we have the OAU Charter on page 2 of that. That is obviously no longer valid, right? This has been replaced by the African Union Constituted Rights. But the point is, if we look at the history of human rights in Africa, we would perhaps not be surprised that in the initial years, there wasn't an African human rights system. There wasn't a system at the regional level. Why? Because states had just been fighting colonialism and oppression, and they were very, very conscious of their own sovereignty, and they emphasized the principle of non-interference. So under the OAU, actually, there was little criticism of one state by another. Right? So we're not going to go into a long history, which is complicated and diverse. But the point is, in the time of the OAU, we had, for example, Idi Amin in Uganda. You know, I think most of us perhaps know that he's been, at least seen to have committed very serious human rights violations. The OAU at the time would say nothing about Idi Amin because the principle of non-interference was understood to be like states should be left alone. But towards the end of the 1970s, these very same states came together and they adopted the African Charter on Human and People's Rights. I think it was possible for them to do so because Idi Amin was deposed, and some other notorious dictators, such as who was the Emperor Bokassa in Central African Republic, they all were deposed at that time. So it created a kind of window of opportunity for those leaders within the OAU to come forward and say, we need to have also some form of a human rights framework that can create this benchmark and create this kind of safety net. So against this background, the African Charter was adopted, and I will also refer you to where it starts in this book, in this text on page 29, because that essentially is the document that is most important to us, right, as Africans. That is the African Charter on Human and People's Rights. So it was adopted in 1981, and it is important that we also remember now, so sometimes, we also realize that we have obviously not all done international law and so on, so I'll just make some small... The first thing that can happen to a treaty is that it is adopted, right? Who adopts a treaty? It is the AU, right? That's important. It's the highest body within the African Union that adopted the African Charter. Now, does it mean that it is in force at that time? No. The adoption is not the entry into force, right? Between the adoption and the entry into force, we need ratification by states, right? Ratification is not signing the treaty, right? So I also don't like, because it's confusing, the word signatories. If you are a state that had ratified, you are a state party, right? That's the easiest to understand. State parties have ratified treaties. And then, in the case of the African Charter, the entry into force was in 1986 on 21 October. I know I mentioned that because that is African Human Rights Day. So that's one thing that you can almost note. If in your organization, perhaps you want to celebrate one day that reminds us of the African Human Rights System, it should be 21 October, because that is African Human Rights Day, because it's the day when the African Charter entered into force. Now, a majority of states ratified the African Charter by that time, and it entered into force in 1986. So, if you look at the African Charter, and others will look at it later today, you'll see that it is somehow a product of compromise. It has a Commission on Human and People's Rights, but it does not have a court. Okay, so when it was founded, the African Charter was given a commission which is not a body that can give binding judgments, right? The African Commission is, in a sense, more like almost a diplomatic body that gives recommendations. So that is how the Commission was established under the African Charter. But in terms of the rights in the Charter, they are very expansive. They are very expansive. If you browse through the African Charter, you are going to see, all the rights you are familiar with, rights not to be tortured, freedom of expression, and then even the African Charter was very, very, very forward-looking because it has socio-economic rights inside the same document, right? At the time when it was adopted, it was quite contentious. If you look at Article 16, for example, that is page 32, you'll see it says every individual shall have the right to enjoy the best attainable state of physical or mental health. 17, the right to education, and 18 talks of the right to family. So this, I want you to just browse through. You can see the African Charter. It is a good, solid human rights document, but it had a weak implementation mechanism, which is the Commission, or relatively weak, right? It's not a court. It is a quasi-judicial body, as we say in law, a body that makes recommendations only. It also had these clawback clauses. Let me just give you one example of what is called a clawback clause. Article 9, sub-article 2. That's page 31, right? Can you see what would be the clawback clause? Do you think what seems to be clawing back the right that is given in Article 9.2? What do you make of Article 9.2? Does it sound a little ominous? If you are with us in the African Charter, right? That's page 31. Looking at Article 9.2 of the African Charter. Yes, please. Okay. It's a very gender non-sensitive, right? So we know that and we see that as well, but we understand that to be inclusive of everyone at least, right? But you have the right, but you must do it within the law. So it looks like you get your rights, but then you are restricted by the law. Can you see that? Because then it means that if you look at South Africa, then if South Africa has a law, then the AU law, even if it's a higher or a different level of protection, it doesn't matter because it is restricted to what is law in South Africa, right? That is how it looks like, and that is maybe what some of the drafters intended. But fortunately, we can say the Commission interpreted this very broadly. So those clawback clauses do not mean that the state can just restrict rights by making laws. It is very similar to what we have in South Africa with the proportionality test, to use that term. It means that, yes, states can restrict and limit rights. That is always possible. But they can only do so if they have law that is accessible, publicly known law that serves a very important societal objective that's justifiable in an open and democratic society, right? So all of that was imported into those clawback clauses by the Commission when it started interpreting this African Charter. Yes, please.
Yes. Do you mind elaborating more on Article 18.4 on page 32?
So 18.4, you see it says the aged and the disabled shall also have the right to special measures, protection, and so on. Well, you can also see the wording, right? It's the 1980s. Today we would not say the aged, but older persons. We would not say the disabled, but persons with disabilities. But I think at least it shows an awareness and a concern for those very often vulnerable groups. And what I will say to this is that there are now 2 protocols to the African Charter, which deals with these rights in much more detail. So they have been neglected in a way because they're not spelled out what it really means, as you can see there, right? It's very kind of almost just in passing. And the same is true of women. If you look at Article, the one just before that, 18.3, it says, the rights of women need to be protected, but it doesn't elaborate. So I will come to this point just now, in the few minutes that talking about these protocols, but thank you for raising that already. So, the African Charter was adopted, as I say, in a sense, as a document of promise, but with some kind of efforts to also weaken it. So, it is to the credit of this Commission, the African Commission on Human People's Rights, that it has I think, been quite progressive in the interpretation of the Charter. So that's why, at least for us as a centre, we see ourselves working with the Commission, because over time it has really been an authentic, legitimate body that has progressively interpreted the African Charter, despite the fact that perhaps there were possibilities of eroding the rights in the Charter itself as well. Okay, let's go to the next slide, Viljoen. So now, just to say that in the African Union, you have to note that, you know, the human rights bodies are there, but you have the political bodies, which ultimately, in a sense, have to ensure that the decisions of the human rights bodies are being effectively implemented, right? Because who needs to implement the decision? The states. And the states really sit together as the assembly, that's the heads of states, the presidents and prime ministers, or they sit together as the executive council, which will be the ministers of foreign affairs, or with at the level of ambassadors who are there in Addis Ababa. So, you know, again, just saying that we have to realize and work within this reality that the recommendations need to be applied by the states. And the pressure on the states will come from these political bodies. But these political bodies are often reluctant to be too critical of their fellow states for various reasons that we can imagine, right? And that is where civil society comes in. Because it is only when civil society in the various states start to raise the cost that the states may suffer from not implementing the decisions that the states may be pressurized to do so. I think you'll agree, right? So it is very much up to the media and civil society organizations broadly to make people aware that the African Union human rights system exists, that it has given recommendations or decisions against our government, and that the government is supposed to abide by those, and that it doesn't, and that there aren't good reasons to do so. So if that does not exist, the governments will get away with not implementing the decisions, right? Because there's no pressure on them. And the pressure, we have to concede, the pressure that comes from the AU itself is limited. In an ideal world, the AU heads of states will pressurize another state and say, but this is an AU decision, you need to implement it. But it often is not as strong as we would wish it to be. Therefore, civil society is the national kind of, but more about that in the afternoon when we talk about that specifically, right?
Sorry.
Yes, please.
Tell me, what is the reason of not wanting to implement the decision?
I'm tempted to leave it to the afternoon session, but you know, because I have a lot, clearly states, it depends a little bit on what decision it is, right? But states will often invoke this notion of sovereignty, right? That they say they are sovereign. But remember, that does not stand. Because a state is sovereign, but its sovereignty is ceded, right? It's limited if it accepts treaties. Because the state is not forced to accept treaties. If a state voluntarily accepts treaties, those obligations are binding on the state, right? So, yeah, the states really sometimes live in a world in which they invoke sovereignty in a very outdated way without incorporating the fact that they have ratified these treaties. They often will invoke various reasons. The most difficult ones are political, right? So let's say the state is ordered to release a political prisoner. You can imagine, the state refuses to do so. The other states are not going to put too much pressure because they may also have political prisoners that they're not released for whatever reason. So there are limits to very sensitive issues being fought for by the political masters, as it were. And that's where civil society's role comes in.
So would the charter be binding on a lawless state, for instance? On
a lawless state? Yes, it is. It is. I mean, my favorite, in this regard would be a state like Eritrea. Eritrea, as you may know, is a small state, but it doesn't really have the rule of law. It doesn't even have a functional constitution. It has ratified the African Charter. It is there at the sessions of the African Commission. So it still tries to use the language of human rights, and we have to contest it, right? Because Eritrea will say, but we are respecting socioeconomic rights. We have very good feeding schemes, we have very good hospitals. But on the other hand, there are many people who are languishing in prison for many, many years, right? So it's also complex, right? States have some rights that they really champion, and others that are their weaknesses. And we have to, as civil society, drive and identify those hypocrisies. Yes, please. So, then the OAU was transformed into the African Union. And the African Union has its own constitution, and I'll just take you back to, those few first pages was the OAU treaty, and on page 4 and further, you find the AU Constitutive Act. Because if you want to engage with the AU, that is its constitution. The AU is a much more human rights friendly body compared to the OAU. By this time, the AU pronounces itself as the protector of human rights. Right? So that's what the states say they are doing. They are embracing human rights. No doubt about it. The AU is a very human rights friendly framework. So we should hold the states accountable. Right? Even if they transgress, this is what they have committed themselves to. So you can see Article 3, there's, for example, accelerate political social integration and so on. Article 3, G, the principles of political participation. Article G, H, 3H, promote and protect human rights. All these things the states commit themselves to. But the most dramatic one, if you like, is there in Article 4H. What do you make of Article 4H of the Constitutive Act of the African Union? You can see it there, right? The right of the Union to intervene in member states pursuant to a decision of the Assembly in respect of war crimes, genocide, and crimes against humanity. Because we said in the OAU, it was all about non-intervention, right? But here you have the AU actually allowing itself to intervene. But interestingly enough, just before that clause on intervention, there's also clause G, which says non-intervention by any member state in the internal affairs of another. But those two are reconcilable. They are reconcilable. Who can quickly reconcile them for us? It's not that they're contradictory. Yes, please.
Wouldn't it be because the right to intervene in those instances are international crimes and those affect the community, the international community as a whole?
Yeah. And let's say in this regional community,
Oh, regional,
African
sorry.
Union, yeah. So it's a kind of an exception. It's only for war crimes, genocide, and you can imagine this comes after Rwanda, right? Rwanda happened in the time of the OAU. The OAU was very silent about what happened in Rwanda, right? Now we want to have a post-Rwanda situation. But there's another kind of reason why the two are quite different. Yes, please.
I think in this case, AU is trying to respect the sovereignty of given states.
Yeah, it does still. We can't deny that.
And meanwhile, making sure that war crimes, genocide, and other crimes are...
Okay, the most serious crimes, we can see intervention, but otherwise we respect sovereignty.
Further to that, the proviso there that the intervention is only premised upon a decision of the Assembly.
Yeah.
So without a decision of the Assembly, then there is no intervention.
Okay, I think that comes closer to the point for me.
Intervention is for a state interfering with another state. When they grant themselves the right of an African Union, that's interfering, not a state.
Exactly. So if you like, G is bilateral. South Africa can just not interfere in Zimbabwe. Right? We cannot intervene. We can criticize them, but intervention here is really, we can almost like take forces and go and restore human rights. But the H is multilateral, right? So it's when the AU itself as a body decides, then, and it means that they can actually take a peacekeeping, a force that goes beyond peacekeeping, they can go with the soldiers brought together under the AU umbrella, and they can go and protect civilians in a country where the country cannot protect its own nationals. So that is what it is, right? Because if you think about Rwanda, what could have happened is that the OAU at the time could have sent forces to actually fight on behalf of civilians whose rights were that is what intervention means. It's very far-reaching. Okay, but that's what the AU Constitutive Act allows. Now, we just have to kind of temper our enthusiasm, if you like, by the reality that Article 4H has never been applied as such. You had Darfur, which was the most obvious place, right? We all know in Sudan, in the southern parts, in Darfur, western Sudan, there were very serious human rights violations. Everyone agreed that they were at least crimes against humanity, right? And that is already the threshold of Article 4H. But for various reasons, and which is complex. The reasons are complex. Some of them are related to finances, resources. To have such a force go, who's going to pay the money? Where is the money come from? Where do the soldiers come from? 2004 was early in the life of the AU. It was perhaps not yet capacitated, to use that word, to do that. But we also have Somalia, the DRC, Burundi, situations where, very, very massive human rights violations took place. What the AU does is it engages in peace talks. So it's not that the AU doesn't do anything. It does many things, but it doesn't do what 4H allows it to do, namely to actually take a force and go and protect the rights. And maybe it is very problematic, but I just want to give us a reality check on that. Now, this is the building of the African Union, just to give you a sense, in Addis Ababa. So it's a serious institution, right? It is really tries to portray itself as such. It is a bit unfortunate that the building was built with the resources of China. And if you look at recent times when China came up in the Human Rights Council on votes, and you see all the African states voting with China or at least abstaining, then you were reminded of these things. There wasn't any direct strings attached, right? But that is the kind of diplomatic influence that perhaps is used. But I wanted to give you this picture because of the comparison where the OAU was. It was a weak institution. The African Union is a well-functional, very well-structured organization. We can take it seriously. But even if the OAU became the AU with all the human rights, declaration of intent, it didn't overnight change the people who were the heads of states, right? So that kind of photo just wants to remind us of that. You can see there's only one woman there, and you recognize her, right? Yeah. Because and she was not the head of state even. She was, as you know, at that time the head of the secretariat, the chairperson or the chair of the African Union Commission at the time. So the point here is, yes, the OAU has been transformed into the AU. The AU is in principle much more human rights friendly body, but it also doesn't mean that it has changed everything on the ground. It cannot. A paper cannot change realities, but it can steer them, it can influence them. We in South Africa are fortunate that we have a very receptive government in principle in many, many ways, right? So we should focus on that and hold our government accountable and see where this regional system can assist us in taking. Now, briefly speaking, the African Union has adopted a number of treaties which all have either entered into force or are still pending their entry into force. We referred you to the African Charter. Just to give you that information, South Africa is certainly a party to the African Charter, and so are 54 states. Can you guess which one state is not a party to the African Charter, the mother of all our charters? That state that doesn't like the Western Sahara to be self-determining? Morocco. Yeah. So Morocco is not. Morocco is a member of the African Union, actually left and came back, but it is not accepted the African Charter. There's a refugee convention for those of you working on that, right? The 1969 Refugee Convention, South Africa is a party. There is a separate treaty on the rights of children. And that is an important fact, and you'll see we also have a session on the Committee on the Rights of the Child. So we should emphasize that there is a self-standing treaty on the rights of children. Treaty on the rights of the child. 49 state parties, almost all 55, South Africa is in there. Then we have a number of protocols to the African Charter that add to the substance of the African Charter. Right? So let me draw it like this. So the African Charter is our main treaty, but it also has seen the adoption of 4 protocols. A protocol really is a treaty. It is as binding as any other treaty, but it is just like a complementary treaty, right? It's an adjunct to the original treaty. The first one is the one on the rights of women in Africa. You know the way in which we refer to it, who works with that treaty often? After the city when it was adopted, it's called the Maputo Protocol, right? So Maputo Protocol has been in force, it's a really powerful document, and South Africa is a party to it. Then we have these 2 protocols that have come, the third now here. A protocol on the rights of older persons that we mentioned, a protocol on the rights of persons with disabilities, and a protocol on the rights of social assistance, right? It means that if they are enforced, they will help states to beef up and further reinforce the layers of protection for older persons, persons with disabilities, and social assistance. But as you can see, regrettably, Only 6 states have ratified this one, older persons. Only 3 have ratified this one
One.
on persons with disabilities, and none so far. But okay, this one you can see is very recent, right? It was earlier this year. First question, I'll come back to the why question. When does a treaty enter into force? So these treaties have now been adopted by the African Union. We're very happy, everyone applauded that, but they have not entered into force. There needs to be ratification by a sufficient number of states. But what is that number? How do we know that number just by law? You get my point, right?
Yeah.
So a number of states have to ratify. How do we know that number? Where will you look for it? If someone says, okay, you are now an expert, you've been through the sector for even understanding, where do I find the answer? You'll have to go to that protocol, right? You have to go to the protocol itself will tell you. There's no golden rule. The protocol in all of these cases says 15. That's a low threshold, right? Only 15 out of the 55 have to ratify, and then this protocol will enter into force. But even if you think 26, that's about 1 state per year, right? So if we keep on going at that same rate, we need another 9, right? 9 plus 20, 22 is 2031. If we keep at the same rate, the first one on all persons may enter into force in 2031. That's not very good for our system, right? Because we have a fanfare, we have new norms, but states are reluctant to ratify. Why is a good question. Has South Africa ratified any of these? No. And that is our low-hanging fruit, right? Let us all reflect on, once we see the protocol, we can look at it and decide, is it a good thing for South Africa to ratify? You can maybe use your own endeavors to try to get them to ratify. But your question is why? Why do you think South Africa has not ratified it? Did you know about this protocol before I mentioned it today?
No.
So South African government also probably would say that, right? So it's a matter of knowledge. No, it's a serious point. So many people know lots about the UN human rights system, but they know very little about the African Union human rights system. And, that's just maybe the way it's portrayed in the media, how the government engages, the political pressures, and so on. So let's make it our mission to perhaps try, where we can, to take the African Union instruments and give them greater salience, right? Increase awareness. So that it's seriously, we engage with the government officials in Banjul from South Africa who are not aware of these treaties, right? So, yeah, so you could say that they should be better informed. But, so that's a level of information. And the second is perhaps that there are different standards at the UN level. If you take disability, you may know about the CRPD. Do people know about it? The UN Convention on the Rights of Persons with Disabilities. South Africa ratified it. Government is very well aware of that, but it doesn't get, the regional instruments do not get the same kind of, let's call it exposure, and there isn't the same level of awareness. So part of what we're trying to do here is to spread the message and the word, and whoever can push this forward. It is important that we have a regional one, because the regional one, if you compare it, the Protocol on the Rights of Persons with Disabilities, you compare it with the CRPD, the UN one, there are many features that are very specific. They're not contradictory, but the African one, for example, looks at independent living in a different way. It looks at things like cultural practices and albinism and issues that are, at least across the African continent, of greater pertinence. So, that would be part of the arguments, and in the afternoon we're going to come back to that, right? Part of what we will interrogate is, how we can perhaps get involved in any such campaign.
So how can civil society organization lobby for these treaties to be signed? Do we have to approach our representatives in Banjul or members
No, I
of
think we have to start here, right? Because remember, in South Africa, at least, it's a process that goes through Parliament. So we have here, and I'm just going to put them here. There isn't enough for everyone, but we have some brochure about that that is also available electronically. But honestly, Felicia and Brian, we will look at this in the afternoon. It's one of the specific items that we want to look at, right? So we have almost like a memorandum that people can use, but it starts in South Africa for sure. It's about, even at the provincial level, getting someone who takes this seriously, getting champions in government who understand that this is important and want to take it up. Yes, please.
I'm just wondering on the different that are available, where you have a scenario where the perceived offending body is an entity of the African Union or the African Union itself.
Yes.
And there are issues at a local level with the declarations basically giving jurisdiction to the court. What procedure would be the best in as far as taking these entities to the African court? For
Like,
example, the
yes.
African CPC.
Yeah.
There are issues with the African CPC, and it becomes necessary to take a legal
A
approach
legal approach.
to challenge the CPC.
I hear you. That's a very, very good question, but a complex one also, because I can go back to this, right? The charter, the protocols, all those documents there are open to ratification by states. So, you know, the rights holders are us and the duty bearers are the states. So we have to, I mean, there are actually some examples of states collectively being taken to court, because, you know, all the states that have been responsible for the decision. So in a sense, you'll take all the AU states that have created the CDC for the neglect, you know, it's a bit complicated, right?
Yeah.
Can you take a case against the AU, you know, as a body? That, again, you know, will depend really very much on the specific issues and so on. But it's interesting. But I think perhaps from our point of view, it should be not impossible to also say, but let's say South Africa, you are a member of this and you've been, in this particular way, you have applied the CDCs, whatever, and that is violating rights. So try to frame it, I would still suggest, as a case. It's unfair in a way because South Africa is not the primary responsible party, but through its engagement, it will affect the others. I know that my time is running out. Yes, I take your question gladly.
Is it for any reason that we do not have the CEDAW Convention as a core treaty, especially given the noise around violence against women and so on? I don't see it.
The UN one, right?
Yes.
Okay, now these ones I've listed here are all the African ones, right? So these are the African Union treaties. I acknowledge, for example, I mentioned here that we have the CRPD and we have the CEDAW that I think many of you know, CEDAW here, right? Against women. You have the CRC at that level, at the UN level. But I'm trying today to make the point that even if we have that at the UN level, we also want to support. Sometimes, you know, there are similarities, and sometimes the argument is one more of solidarity and expression of an African position rather than tangible results. But I think in all these instances, the African instrument, like the Maputo Protocol, provides for rights in a much more African-specific way. Again, it does that, whereas the CEDAW is quite general in its framing.
Sorry, I just also just wanted to add on to that sometimes in some instances, you know, the African conventions have actually been a little bit more progressive than even the UN ones. So even the Maputo Protocol might even have stronger, you know, clauses in it than what exists in the CEDAW. You know, like for instance, the rights for incarcerated women are stronger.
Exactly.
Yeah.
And more sensitive, you know, like not this blanket rule, for example, you know, all women cannot go to, you know, prison with their children. So it tries to be more nuanced to the circumstances. And take one thing, child marriage. The African Children's Charter, this charter here, is explicit that no child can get married. So 18 is the draw, and the line is drawn at 18. The CRC is much more ambiguous. It allows for some exceptions, right? So you can say the African instruments are more ambitious, not always conform within the reality, but it is important to have a normative standard that we are all aspiring to and taking the states to hold in accountability. So let me just make one last reference here, and that is to the IDP Convention. I'm coming to you. IDP standing for internally displaced persons, right? So as you know, we have refugees, obviously people who cross the borders, but then we have IDPs, people who are displaced in the country due to whatever reasons, maybe natural disasters, sometimes political reasons, and so on. Do we have IDP problems in South Africa? People who are internally displaced?
Yeah, it is.
Yeah, it is. So you see 33 state parties against South Africa, not a state party. South Africa, not a state party. And in this case, there's no UN comparator. There isn't a UN treaty that we can say, no, for in the IDPs, we are okay because we have the UN treaty. No, it doesn't exist, right? So we have a strong argument, I think, to make that South Africa should ratify, for example, the IDP Convention. Yes, please.
I'm just wondering, because looking at the instrument, there is no instrument that I see which speaks particularly the rights of indigenous persons. In a scenario where indigenous people want to challenge their government who are not getting any headway within their government structures, what approach would be advisable, particularly for states that have not declared jurisdiction to the African court?
Okay, that is good. And Viljoen, we will remember that Pansy Takula, who's going to talk about the Commission, the best work in this regard has been done by the Commission. So even if the word indigenous people is not mentioned in the African Charter on Human People's Rights, the African Commission has interpreted the broad wording to actually include indigenous peoples. And here we talk about people like the Khoi and the San, right? The term indigenous is also contentious, but we'll come back to that if you don't mind when she speaks, because she's been somewhat involved intimately. I'm going to conclude by just the last slide with the entities. Yeah, the entities, that one. There. Just then to, in a sense, summarize and now draw us to where we'll go in the next a few sessions. Essentially, we have three bodies which interpret all these treaties that I referred to. We mentioned the African Commission. It is there to adjudicate and promote the African Charter and all those protocols that I referred to. But that treaty on the rights of the child, the African Charter on the rights and welfare of the child, it falls under the auspices of a different body, right? And that body is called the African Committee on the Rights of the Child, or the African Children's Rights Committee, just so that you see. I think we were very optimistic because that comes from the 90s. We thought maybe we'll have a committee for children, for women, for persons with disabilities, but when we, the reality sunk in that it's very resource intensive. So it's a bit of an anomaly, isn't it? Because why is there a body for everyone and then for children? And then, for women, they all come back to the African Charter, the Commission, the older persons come back to the Commission, and so on. I just kind of explained that in a historical sense. And then we have the court. We have not mentioned it, but there was then, in very, very brief terms, as I think most of you know, there is a protocol that established the court. So that is another protocol which was adopted to the African Charter. But these protocols that we mentioned on women, older persons, persons with disabilities, and on social assistance, they are adding to the substance, to the rights in the Charter. And that protocol on the court adds to the procedures, if you like, and it creates now a court to complement the work of the Commission. More about that by our next speaker. So let me stop here because I've transgressed my time. I don't want to be a transgressor. And then we'll hear from Victor more. But once again, I hope this sets the scene. Remember now that you have this gift from us. We can remind you of these treaties, but they're all on the website, the ones you don't find. So let us see how the discussion goes. Obviously, I'll be in and out, and I apologize.
But if questions.
Yeah, if there are burning questions, we did allow questions through, but I was allowed by the moderator. And by
Yes.
Yes, please.
Why is the African Children's Rights Committee very prominent as compared to the African Disability Committee, if there is such?
No, but so we only, there's other entities, but we don't have a treaty body, right? We only have two treaty bodies in Africa. In other words, African Union human rights treaties, which establish a supervisory mechanism. So it has that official status, right? The one is the African Commission. It is there in the African Charter as the body that supervises the African Charter. And in the African Children's Charter, which is an AU treaty, it has this committee on the rights of the child, which supervises that body. So other bodies within the AU are more political and so on. But these are bodies of independent legal experts, which are the authorized body in terms of the treaty. Does it make sense?
Yeah, it does. In a way. Yeah.
Okay.
Yeah.
We'll come back, and I'm sure, hopefully, through the course of the day, if something is not entirely clear now, it was obviously just a rough overview, and it will be complemented in due course. But let's hear if there are any further immediate questions.
Maybe we'll need an organogram just to pinpoint the treaties, the protocols, so that at least we can have a bird's eye view of the hierarchy of,
Okay, but so to reiterate, like I said, the African Charter and its substantive protocols, all of those fall under the jurisdiction of the African Commission.
Yes.
The African Children's Charter, which is a separate treaty, which is also in your text, it falls under the African Children's Rights Committee's auspices. They are both, they look very same, these two bodies. There are 11 members, they have a promotional and protective mandate. And then the African Court really has a very expansive mandate, but it's complex, and Victor will tell us a little bit more about exactly how it works.
Okay.
But that's a good point. We can put something together and maybe share with people, right?
Yeah.
Some form of an organogram that shows those linkages. We appreciate also being directed about what would be useful to you.
Yes.
So we can do that for sure. Okay. Anyone else with something now? Yes, please.
You mentioned the fact that the African Commission makes recommendations. In the event of a recommendation being made and the member states against whom the recommendation has been made chooses to just laugh it off and ignore it, what recourse is there?
Yeah, again, it's really then at the political level. So in a sense, we are saying these are legal bodies, right? They are legal experts, they apply the law, they tell us that in the law, you've committed as a state. Let's take the case of, there was a case of Good. There was someone who was a lecturer who criticized the government and was given like 24 hours notice to be expelled from the country. He brought a case against Botswana, and Botswana, because it is a politically sensitive case, and the recommendation against Botswana was that they have to, at least change their laws, grant protection, pay compensation, and so on and so on. And Botswana refused blankly and said, no, we are sovereign, we can decide when we want to expel someone who criticizes us. But clearly that is at odds with the African Charter and the obligation under the Charter. You would now want, in the first place, the political heads. When these matters are discussed, where is it discussed? In the forum of the African Union, right? That is where the political pressure has to be put on Botswana. Botswana, you cannot do that. You cannot say, I'm a party to the state, I'm a state party to the African Charter, I've accepted the African Commission's jurisdiction for all other matters. But today, I challenge their status because I'm contesting this. So it's been done by some states, but it hasn't been done strongly against Botswana. So again, may I deflect it back to us? At least if academics, civil society, media come and say, but this is ridiculous, Botswana. Those in Botswana, those in other places can point out the hypocrisy. Because you want to be a party of this, you've committed yourself, and you have always observed all the others. You've never contested, that's true of Botswana, you've never contested that you're not being, at least you have a bona fide, you have a good faith obligation. Even if it's not a legal obligation, it's a good faith obligation because you are part of the system. You cannot undermine it by invoking some authority to not abide by it. But it is the kind of challenge of international law, right? Because at the domestic level, we also know that implementation is a challenge because, but then there is the idea that someone can be really held accountable because of contempt of court, essentially. There isn't a contempt of court proceedings at the international level. Therefore, we have to galvanize the attempts that are sometimes political by our efforts as civil society. Okay, let's leave it at that, Felicia. Thank you very much for your attention. I hope it's useful, and I hope you will all find yourself to be somehow experts with the assistance of sources that you may become familiar with. So, thank you very much.
Thank you.
Our next speaker is okay, so it will be at 2:11, and I will request all of you to maybe keep your questions at the end so that we can also look at the questions.
Hi, Victor, can you hear us? Hi, Victor. Hi, Victor.